You're 30, maybe you're thinking, I don't need a trust. That's for big shots.
72% of people in our country have done nothing.
I believe it.
I think about a business owner like, I don't want to go and do the estate planning. It's going to cost a fortune. But just think about the cost that you're going to put on your family without having a trust in place.
If someone dies in a situation with a lot of assets and a lot of undocumented ownerships, then the loved ones are like playing financial detective on the back end. I just finished up a probate on my mom and dad's farm. It was a big mess and it took forever and it was expensive.
Let's say you're one of these 72% people that are naked out there. You listen to this episode, you're like, all right, I'm getting a will done.
Expert advice, practical tips, real life stories. Have less stress, more time, and more money in your business. Welcome to the Cashflow Contractor.
Martin, we've got another Marty
I know.
on the podcast today.
Yeah.
Wow. How long have you known Marty?
Well, really not that long. I've known of him, but I've really only known you a couple of months, right?
Yep.
Marty?
I think so.
Yeah. No,
Great.
my name's Martin, of course. Marty's is actually Marty, I think. I asked you that. But when I lived in Nebraska, everybody called me Marty. So if I get a phone call and well, now I know because of caller ID, but it used to be I could tell right away where they were calling from. Marty, how you doing? And down here, it's Martin. Who's Marty? Me. It's I. Anyway.
That's great. Well, Marty, welcome to the show. So you're down the road from me, which is crazy. I've passed by your office so many different times, but you're an estate planner and you're an attorney that focuses specifically on estate planning. How did you start your practice?
Well, having been an attorney for about 35 years, and I kind of transitioned to doing estate planning. I had lived in Norman and raised my family, and we made the decision in 2008 to open an office here in Norman and focus on doing nothing but estate planning.
Wow.
That's a good time
why
to not
Norman?
go into real estate, right? 2008.
Yeah, really good time.
Yes.
So why Norman?
Well, went to undergrad here at OU, and immediately after graduating from OU, I went to OU Law School. That's where I met my lovely wife and law partner, and we got married right out of law school in 1991, and started raising a family and loved Norman, and just decided to stay here. And we were both working and commuting to Oklahoma City, but loved the college environment, town. I just made a lot of friends here. Wanted to stay in Norman.
That's great. So Martin, gosh, this is going to be tough for me. Martin. Martin,
Yes, sir.
you got serious about your estate planning,
Right.
what, 5 years ago, something like
No,
that?
no,
Like really serious?
2006. Literally, we were going sailing in the Caribbean with a friend on his catamaran, and there's an ocean and a sailboat, and we started thinking as if we were mortal, and we'd have some kids, and we thought we ought to have a will. And so it kind of started with that, and I think we'll hear Marty maybe help. But we think we ought to have a will, and then we find out, well, this is what a will does. Maybe we ought to have a trust. This is what a trust does. And since then, I'm very glad we did it. That's why Marty's here today. This is not construction. This is a business owner, normal people. And let's say you're just really young, 26, 27, 28. That's pretty young. You're 30. Maybe you're thinking, I don't need a trust. That's for big shot. Well, you get the thing set up and get used to putting things in the trust when you buy them. And Marty's going to talk about that. And you're going to be so far ahead of the world, so far ahead of me. In 2006, I was already, however old I was, 45 or something, 50. Really? It's 20. Oh, yeah, it's 30 years
you're
ago.
close to that.
Yeah, I was 45. Yeah.
Yeah.
Something like that.
It's great.
Yeah. So anyway, I thought it was a worthwhile topic that our listeners at least hear this because it's important. All the work that you do and then we'll talk about why it matters to have a trust, but have everything in a trust early on. You just understand how the world works a little bit better if you have a trust too. So I won't.
I think what I
Anyway,
was referencing, Martin, 5 years ago or so, you were like getting serious about what happens if I die or something like
oh,
that.
well,
Like your passwords, and like you were getting really serious about
death,
that.
muerto. Yeah.
Yeah.
Black crow. No, I don't know that I have any. No, you're right. 5 or 6 years ago, we did because we've got some new businesses and different things, and kids
Yeah.
are older. But I was just
That'll
as
apply to
serious
this as
in
well.
2006, just as serious. Didn't view death as imminent. Don't view it as imminent right now, but we've gone through it several iterations. Doing one, and it
Okay.
kind of, we'll talk about it, but they tend to drift into disrepair, and you need to do it again and again. So 6 years ago, I was in the middle of doing it again and again. We bought some property
Gotcha.
and get those things
Okay.
titled in the name of the trust and yada, yada.
So Marty, Martin's all set up on his trust. He's got it all figured out. I don't have anything figured out. So this would be a good little balance here. But what do you see most business owners do? And what's unique about business owners when it comes to estate planning?
Well, what's unique about them is that their business is really like their baby. I mean, and it's a lot of their identity and is tied up in the business, and they have very strong passion and ideas about how they want the business run. And if something were to happen to them and they were to get in an accident, become disabled, or have some type of medical event, or pass away suddenly, those are the issues that for business owners is how is this business going to go forward? And in the event of my disability, who's going to step in and make decisions about how to keep this business running, or how to, maybe potentially sell the business for the benefit of the family or the beneficiaries. And so those are important things that I see come up with business owners in the estate planning process.
Okay. So what's the starting point? Like what's the best way to get in?
Well, the starting point is getting some education and learning about the different tools that are used in estate planning. And as Martin mentioned earlier, each of these tools have their pros and cons. And if you don't have any estate plan in place whatsoever, you want to think about, sit down with someone who's knowledgeable about the topic and learn about what a will does and what a trust does, and go through a discovery process. And I identify your goals. Number one, what are the things that are important in your life and the things that you want to protect and the people you love. But also it's important to start, no matter which direction you go or what legal document you choose, is you need to start making an inventory of all of your assets and how they are titled, because everything in estate planning ultimately comes down, in the event of your disability or death, is to who is the legal owner of the asset.
So what's the best way to handle that whenever you're thinking about who's the owner of the asset? What's the correct answer? I'm sure there's a couple of different correct answers, but yeah.
Well, on like banking accounts, for example, checking accounts, the name on the signature card is considered who is the owner of the account. Most people, it's the individual owned it, or a married couple, they may jointly own the account. They're both on the account. It's what's called a joint account. So for a house, you look at things like the deed on the house. How did you take title to the house? And usually at the closing, you would be provided a copy of the deed, which reflects your ownership of the property and how it was titled. Is it titled in your individual name? Did you buy it as joint tenants with your spouse, and do you own it jointly? So those are issues that when you start thinking about estate planning, you want to go through the process of identifying all of those things and how they're owned, basically.
Quick ad break to tell you a little bit about OpenPhone. If you're a contractor that has a single cell phone, you're probably inundated with text messages and phone calls, oftentimes that you can't be responsive to or that you can't answer at all. So what's the solution? You can buy another office line with Verizon or AT&T, and you can have an iPhone that is passed around from employee to employee, depending on who's on call. But what if there's a better way? What if there's a way that you can have all your phone calls recorded to go back and listen to later, transcribed with summaries so that you can get a quick glance at what happened during the phone call, and even connect it to your CRM where all your other customer information is? OpenPhone is the perfect solution because it does just that. You're able to add all the users you need to for whoever needs to have access to the lines for your company phone. And then you can also find all of the information you need at a glance with a centralized location for all phone calls and text messages with your customers. Whether it's for marketing, for sales, or for service, OpenPhone is the perfect solution for you and your team. If you're interested, we have an offer down the show notes from OpenPhone. Please click the link down the show notes, or you can see it here on your screen to be able to find more information about OpenPhone. Thanks for listening. Back to the episode. Let's get to the why that matters. What's the difference between, hey, I've got my bank account owned by a trust versus I have it held jointly? What's the issue with that if something tragic were to happen to myself?
Well, if you are a married couple and you own it jointly, or the account jointly with your spouse, and he or she survives you, that necessarily can pass by what's called operation of law, but it just automatically becomes the surviving spouse's account if it's owned joint property. The whole issue about having it transferred or put into the name of the trust is avoiding what is the hallmark of a trust, and we're talking about a revocable living trust, is that in the event of your death, and there's not going to, if everything is properly titled in the name of your trust, you can avoid having to go to the courthouse to go through what is called the probate process. And so that is a big advantage to having a trust, is that in the event of a disability or death, everything can be handled and administered privately by the people you name in the document as to who you want to be in charge, and manage your assets, follow your instructions in the trust, as opposed to having to go have a will and have a judge supervised process down at the local courthouse. So that's kind of the has always been the fundamental difference between a will versus a trust historically.
Could you just say a little bit more about what a probate is and why we want to avoid it and how long it might take?
Well,
I mean, not at a high level, but
yeah,
a judge to operate it.
Yeah,
There's
well-
creditors, kinds of
exactly. At a high level, what the probate process is when someone passes away with a will, it is a document that has to be admitted to have power to distribute the assets to the people named in the will. The will has to be presented or filed with, generally in most states, with the court clerk, and then a hearing is set in front of a judge, and a judge determines, is this a valid will? Is this properly witnessed and signed under the law? And each state is different. Each state generally has a set of rules that you follow, sometimes called the probate code, or And it says that certain things in the probate process, once the will is filed, there has to be notice, uh, generally notice to all the potential heirs, beneficiaries of the estate, in a hearing in case they want to somehow appear and object to the will, challenge the will for some reason. That's usually published in a local newspaper or whatever the state policy or procedure is. Then a hearing is held, and then whoever was named as the personal representative or the administrator of the estate is appointed, sworn in by the judge to basically go through a series of hearings and present evidence to the court that notice has been given to all the creditors out there, that here are the creditor claims that have come in that may be satisfied out of the money and proceeds in the estate, because there's an inventory there that places in the probate process. In some cases it can be waived, but generally, big picture, the judge wants to know everything you own in your individual name at the time of your death. And have you given notice to your creditors and paid off all of your final medical expenses or any valid claims against the estate creditors? And are all the taxes current? And then the judge at the end of that process, I kind of call probate probing. After the court has probed around and made sure that you've done it, have done everything that you're supposed to do, paid all the bills you're supposed to do, and taken care of your creditors, then the judge looks at the document and says, and there's a final decree or order in most states that then transfers legal title or ownership to the surviving spouse or to the adult children or the beneficiaries. So the probate process is a series of steps, meetings at the courthouse, appearances before the judge to make sure all these check boxes are checked off. And then when the court's satisfied that everything's done that the law requires, then the final order is entered, and the surviving spouse or the adult children, they take title to the property. They own it cleanly.
Sounds complex and to be avoided, and it's probably where you meet your cousin that you've never met, who comes down from Oregon and
Can be.
wants a piece of the action.
Can be.
Wants part of those oil leases.
Yes. Can.
But typically, minimum, it's going to take 90 days or something, and maximum it can take years.
Exactly. It's a big range based upon the size of the estate, the type of the assets that are involved. Yeah. It's a case-by-case basis. And some states have accelerated what are called summary administration or smaller estate type things to make it go as quickly and efficiently as possible. But it really, if there's a challenge to it, the validity of the will or anything like that, that can drag on and actually become litigation, what's called a will contest.
So you have made it really clear that a probate is a thing to be avoided if possible.
I believe so. And I have my evidence for that too is when clients come talk to me about this topic. Sometimes one of their big motivators is, I just finished up a probate on my mom and dad's farm or this place, and it was a big mess, and it took forever, and it was expensive. Now that's not true in every case, but like I said, it's really, if someone dies in a situation with a lot of assets and a lot of undocumented ownerships, and then the loved ones are like playing, financial detective on the back end, trying to figure out what they owned and trying to figure that all out during the course of a probate proceeding and present it to the judge.
I have certainly getting the idea on the probate. I know that a lot of people have thought, I among them in the early days, that somehow a trust protected your assets from creditors. and that would be a reason to do it. I know that there's a way it can, but generally that's not the case, right?
That is correct.
Irrevocable.
If it's a
Okay.
revocable trust, just because you transfer your assets or retitle them in a revocable trust does not protect them from your creditors or lawsuit creditors.
Yeah. So in general, and again, I'm thinking of young people who maybe don't have all the estate, but you're starting to put things in there with the twofold purposes. One of them is to say avoid probate. The other is to direct how you want things to happen, who to take over the company, who to be the trustees. So that's worth doing in and of itself.
Absolutely, because generally, and it's all about the level of guidance you want to leave, and your goals and the level of guidance, especially if you're a young business owner. Number one, and if you're young and have kids, the biggest issue is guardianship, and you want to use a legal tool, and at least in Oklahoma and most states, the guardian who would raise your children and in the manner that you would like is generally appointed by the court and is placed inside the will, and that's the way it is in Oklahoma. So that's one level that brings younger professionals to the table, and younger people, business owners, is if they have kids, is, well, we got to make sure that who's going to take care of these kids if something happens to us. But then also some potential advantage of the trust is you can leave. It takes effect the minute you sign it. It doesn't have to have court supervision. The trustees, in the event of your disability or death, look to the document itself with instructions about what are your preferences about living arrangements if you were disabled. What are your preferences about this business going forward? Do you want it to continue, or do you want it sold for the benefit of your loved ones? And so all of those things aren't typically addressed in a simple will. They're just not. Simple will when I say that, that basically says if I die, my property goes to my spouse. If I'm married, if he or she does not survive me, then it is to be distributed to my 2 or 3 kids, generally outright, and the percentage or however you say. But that gets the property to the next generation, the ownership of the property. But in my opinion, the beauty sometimes of the trust is it leaves a lot more instructions and can leave some protection for some of life's risk to our children and our adult children when we ultimately pass away. So those are things you kind of walk through, and as you learn more about this topic and identify what's important to you, that's one of the benefits of trust planning, is you can have a different level of guidelines, so that your loved ones can look back and say, well, it's right here. It's very clear what they wanted to happen with this business, and we don't have to guess or figure out what's in the best interest of all of the beneficiaries. They left some guidance here, and so that's huge.
I think about a business owner like thinking, man, I don't want to go and do the estate planning. It's going to cost a fortune. But just think about the cost that you're going to put on your family without the estate plan, without having a trust in place, so that it goes into probate. And now, they're going through obviously an emotional experience with you being gone, but now they're also dealing with logistical nightmares because you didn't do some planning that could have taken you a day.
Yeah.
Maybe a week. I don't know how long it takes. That's a good question. How long does this setup take,
Well,
Marty?
it depends on who you work with. It can, and the pace that you want to go. Generally, it can be set up over the course of, in our practice, it's usually about a couple of meetings, and it's usually about we spend a little bit more time up front. It can be, or this is usually a 2 to 4 week process to get all the information, because not only are we learning about the family and the dynamics and the goals, we're also beginning that inventory process of inventorying all of the assets outside of the business, like your personal checking accounts and vehicles, things of that nature. Then you've got business owned assets as well. So we start in inventorying that, kind of doing that at the same time we're discovering and thinking about designing this trust. So in our practice, it's typically, it can be, it can be done as quickly as a couple of weeks, but generally it's usually 4 to 6, depending on the size, because it's, you can generate the documents fairly quickly, but that's not is what necessarily is going to make the plan work. What's going to make the plan work is if the people who have drafted the trust know and understand how the plan works, and they have chosen the right people after counseling that are going to step in. Because think about it, when you're gone, disabled, or pass away, how are you going to know your plan works? You're relying upon the trustees or the people you choose to execute the plan on the back end. And so that's when you start thinking about those things and looking at individuals that you want to put in those positions. Those are things that sometimes need quite a bit of thought. Just sometimes it's crystal clear and everyone knows, yep, I want my brother to be my trustee, or I want my parent, or I want my spouse first, but if something happens to he or she, then I want one of my adult children. Well, I don't have adult children yet. So who's going to step in while my kids are still young, or maybe going to college? They haven't even finished school yet. Part of my goal was I wanted to have a secure, protected bucket of money to make sure my kids get through college. And you can do that in estate planning. So with instructions on what to do in the event of, a common death with surviving minor children. That's one of the big things that we focus on, making sure there's a protected bucket of money there.
Quick ad break to tell you about Growth Kits. This is actually my company, and you may have seen it around, but I started Growth Kits because I kept seeing contractors struggle with the same problems over and over again. They were trying to be better organized inside of their business, but kept drowning in the day-to-day operations. So whether you need a better CRM, a hiring process that actually works, or you just want to make sense of the tech stack inside of your business, we have systems that are built specifically for contractors. You can either grab our DIY guides and implement these systems yourself, or you can hire us to work with you on it and implement it for you. No massive consulting fees, no year-long commitments or monthly retainers. Just pick what you need right now and let's get it done together. Head over to growth-kits.com to see how we can help you construct your success one system at a time. That's growth-kits.com, or just click the link in the show notes. Now, back to the show.
One of the things, Diane and I have 3 separate companies. 2 of them are sole proprietorship. She owns one, I own one, we own one together. And we had to put those into trust. And I can't even remember exactly how we did that, but there's a formal method, amendment to the articles or whatever we call it, that authorizes us to do that. And then to document that, we did it. So getting the trust written with the intent that you talk about was not the large, that's the important part. That was not the large part. Getting it effective, because if we say the trust owns the company, but we never put the company in the trust, it doesn't own it. The trust owns my life insurance policies and my wife is the beneficiary. But if I don't put it in the trust doesn't really own it. And
Absolutely.
that was a tedious, painstaking, and I want to put people off of it. You do those things one at a time, and you get somebody who tells you how to do it. Changing the owner of a life insurance policy, lots of people do it, but I've never done it before. And when I finally did, I had to be walked through. So I think they call that funding the trust.
That's kind of the legal,
You'd say-
I say it's kind of a legal term of art for, funding your revocable living trust, which sometimes I use kind of think of your revocable living trust as a bucket or a little red wagon. And funding is the process of you retitling assets, transferring ownership into the name of the trust, but you're the trustee of the trust wearing the hat. You have complete control of the assets in your trust. You can buy, sell, manage them anyhow you want, but you're exactly right. The trust can only control what is ultimately in the trust. And that's historically, it has become if they are doing this funding, this process of retitling the assets in the trust, it can get frustrating and it can get confusing. And, hopefully they can find help doing it. It is a process. It is one of the challenges. And there are many times that I've seen over the years, people will bring me an existing trust that either their parents had or they had from the 90s. And I'll look at it and say, well, well, show me evidence of everything that can and should be owned by this trust that it's in there. Did any funding get done? And unfortunately, the majority of those cases, nothing got put in the trust or retitled other than generally the house. So what happens if you die with a not properly funded trust and you've got all these assets on either married or individual name, titled individually name, you're not only going to have a trust administration for what assets were in the trust, but now you're going to have to hire a lawyer to probate all the assets that did not get properly transferred prior to your death. So that's the key. And we always say, it's kind of common, there's no fun in funding, but if you want your plan to work, you got to dedicate yourself and hopefully you've got some good helpers or some good advice for whoever you're working with to verify that those assets properly got in the name of your trust. But it's great.
What are some of the most painstaking things to probate or maybe more costly, that you hey, I'm just starting my trust. What's one of the first things that I should try to do and fund? Yeah, I've got all these different things out there, but what are maybe the ones that man, this one's going to be a big bite that we got to take care of? Or maybe it's a better approach of just going with the easy ones.
Well, you want to start with the investment accounts. If you've got the cash accounts, the investment accounts, make sure those get in the trust. The house, the deed is fairly straightforward. Business, there's a lot of things that need to be looked at in terms of what are the operating agreements said. Martin referred to that. Once you get the operating agreement done, then you can do what's called an assignment of the interest in the business to the trust. But you want to start with those cash assets, the house, life insurance. Sometimes I recommend changing ownership. Sometimes we just name the individual's trust as a beneficiary of the policy. We update the beneficiary designations in terms of what you really, the big things that you want to get into the trust. So.
Okay. The home seems let's talk about the home. What happens if you don't have the home in the trust?
Well, if you die, if you're married and the home is owned in joint tenancy, which means that you own the home jointly with your spouse. In most states, it means it's usually joint tenancy with the rights of survivorship. What that means is if husband dies first, house was originally bought in the name of husband and wife. Wife just now owns the house 100%. The house doesn't have to go through probate. The surviving spouse, generally in most states, files what's called an affidavit or proof that I am the surviving spouse, and attached is a copy of the death certificate so that the title examiners know, and then a new deed is issued showing that the surviving spouse now owns 100% of the property. They own it in their individual name. So that can pass outside of the probate process. And a number of assets like that can, through what are called transfer of death deeds, or payable on death, or even on checking accounts. But so
Yeah. Okay. So, but what if like both you and or let's say you're solo, or you and your spouse both pass away in a tragic accident? What happens if it's not in the trust then?
then if you have a will, your will will it will go to probate.
And if you don't have a will, like you have got 5-year-old kid and that's it, what
Well,
happens? Like how does it get messy?
well, if you do nothing, most states have an estate plan for you if you do nothing, and it's generally called the rules of intestate, which means dying without a will, the rules of intestate succession. So if you both died without any will in place, generally some close family member would go hire an attorney and file a petition with the court to be appointed as administrator of your estate, and maybe even apply for guardianship of your children, have to start a guardianship proceeding. So someone's going to have to go, if there's no plan, go hire a lawyer to draft up some documents to take to the judge to say, Judge, they died without a will, and we need to appoint me, or appoint someone to inventory their estate and figure out what they owned, how they owned it. And then that process starts under the supervision of the courts. And also, if they died with minor children, probably opening up an application for guardianship for their minor child. That may be a brother or sister coming forward, or parents to hire a lawyer to file an application that, Judge, please appoint me guardian of my grandchildren. Or so
Wow.
it's
So
you gotta.
Hey,
so how formal does this will need to be? Because it sounds like I want to avoid a lot of that. What do I what's the process of just getting a will in place? Is that easier than putting a trust in
Oh,
place?
much easier to get a
Okay.
will in place, because, like I said, a simple will, and you've seen all of these things that are out there available digitally now, and other types of companies that provide wills and online and things like that. And I or a will is basically a lot um, easier to do, because it is pretty limited in what it's going to say. It's not going to have a big, deep level of instructions, or generally not have any type of, depending on the size of the estate, tax planning. But a will can, and especially in our practice, we have what we call a will-based personal protection plan for clients who don't necessarily need or want the complexity of a trust. So we have those types of plans, and they make sense in some circumstances depending on their station in life, their assets, and and what they want to do. So it all really,
Okay.
what percent of the general population, this is just a guess, is naked? In other words, they don't have a will, and they don't have a trust.
Last
I guess.
last figure I heard,
Yeah. Yeah.
well,
I'm seeing one hand raised
yeah.
here.
the last figure, the last figure I heard at a national meeting was somewhere close to 72% of people in our country have done that.
I believe it. So you got to work out that intestate law.
Yeah, and that's
Whatever.
if you die intestate, the judge doesn't have any discretion. The will tells them who
You have to do what it says.
Yeah, it's just a legal chart that says, okay, here's all the assets. Did they have surviving parents? If so, they get it. If not, does it go sideways? If they didn't have a surviving spouse, then it goes to the kids. Or if they did have a surviving spouse, it's divided up. And The judge just has to follow the chart, the formula, and that
You know,
So here's a question. Here's a question. Let's say you're one of these 72% people that are naked out there. You decide, you listen to this episode, you're like, all right, I'm getting a will done.
step one.
Uh, where does that live? Where do you put the will? Is it in a safety deposit box? Like, where do you store this
A
thing?
lot of people will put the original in a safe deposit box, fire
Okay.
safe at home. If you're working with a law office to do them, sometimes they'll keep a copy for it. Or, in the old days, some firms may still do this. They would keep the original will in the vault. But normally, in today's world, I think the client ends up deciding whether to leave the original will with the firm or takes the original will with them. So,
Well, here's a simple little question. A PDF to original with a notary signature on it is that acceptable, or is it got to be
only
an actual?
only if you can prove to the court that you cannot find the original. You've made a sort
How do you prove a negative?
Yeah. Well, I don't have a whole lot of experience in that, but I mean, I do read about it.
Okay, so
Okay.
it's not a problem
Interesting.
unless somebody's fighting it, or is it?
No, I mean, you can, if you have a will, you can generally, if it's a valid will, you can petition and get it approved by the court.
Well, maybe that
I
was
think,
a distraction, but good point.
I know I'm calling on you, Martin, here, and I mentioned earlier, like 5 years ago, you got serious about this. What I remember you going through is like, what happens if I die? Like, hey, if you need to find the will, it's in this safety deposit box. If you need to log into
okay.
QuickBooks, you go to
I know what
this.
you're referring to now. I have a death box.
Okay,
It's
there
a,
we go. That's what I was
yeah.
mentioning.
Okay, I see where you were headed before, and that's what it's called. It's a
Mhm.
death box and a death document. And I'm going to tell you this. I got one pass. All my passwords are in one pass, and I got 150 of them or something. And so I wanted to print those out and put them in the safe deposit box. I didn't know how to do it, so I emailed OnePass, which is a password protection app, if people don't know. And the guys called me back, no, don't print them out. Never print them out. I go, I'm printing them out. And I did. And they're in that box. And about every 3 months, I got to print them out again because of change, So just literally that. My father-in-law died, getting to be a while ago now. But, man, he left everybody. It was easy. Do this, here it is, there it is. It wasn't a huge estate. My brother-in-law actually executed everything. And so I vowed, that's probably the impetus you're talking about, that I wanted to do that for my family. And not Diane too. She's,
Sure.
we're equal contributors here. It's not like I'm providing. Yeah. And
Do,
go
do
ahead.
people ever like record videos? Hey, I've passed. Here's what I want to happen. Obviously, that doesn't hold the legal weight that like the documents do, but I'm sure that can help with making sure that everything is, I don't know, handled a little bit more easily. I don't know. Is that something that people do?
I've seen that done before, and there's a that's very helpful just to especially if you're like where to find something, a video where you find these. I love the idea, and I've had clients that do the death box too, but the instructions, not only instructions, but just personal message and preserving your legacy, preserving some of the family history and stories. We always encourage people to do that. Video is a great way to do that, but it's also a great way to direct people where to go find something, where to go find that list of passwords, where to go find that, that particular file box. And so, in terms of, the will itself, the court's going to look at the actual legal document to carry out. That's the intent.
And
to carry out the intent.
Khalil, I think the other thing about doing it is, I alluded to it at the beginning, but it's an education for you. You don't realize necessarily the assets that you have. and you don't maybe necessarily understand how life insurance works, the owner, beneficiary, and maybe you want to change things. But if you do this, and also I know, Marty, at your law firm, you have a document where you write down significant assets. We have some paintings, and who of the kids do we want them to go to? We've got a lot of things like that, so they become a part of it. And you review that every now and then. Maybe one of your kids made you mad, and you're going to take away the Riviera townhome and give it to somebody else. But anyway, you become aware of who you are and what you own and how things work. And starting young and getting started is, I mean, obviously you're going to avoid probate, which you never thought about, but you're also going to have instructions that Marty's been talking about to influence what happens. And maybe you don't really think about that because you're 30 years old, but you still get those benefits, and you can just start. When you buy a new car in 10 years, you automatically put it into trust instead of doing like we do, put it in joint Tennessee and then go, oh, I got to change it to the trust.
You know, when we first opened our firm here, we had a lot of, early on with a lot of young couples with minor children, just because when Tammy and I started doing this a lot, doing estate planning the way we do that, we'd met a lot of young couples, you know, either through the church or boards or foundations that we served on. But it would always, it's always easier to kind of get, if you're considering the trust planning, like what Martin's saying is that you get this vehicle in place, and then as you acquire it, as your estate grows, you just take title to it in the name of the trust. And so for young people, sometimes, even though you feel like you may not have enough stuff to have the trust, my gosh, you want the language in there that says, what I have, in the event something happens to both of us, I want it protected and managed in this trust to take care of my kids for their health, education, and maintenance until they reach a certain age. Whereas, you know, a lot of my clients will come to me later towards the end of their life, and now it's time to think about doing this, and they've been meaning to do it for a long time, and they've acquired a significant number of assets and have multiple accounts. They've been very successful, but it's more kind of frankly, a pain in the butt to move all that stuff later, do it later in life, as opposed to having the vehicle in place that just sits there, and as you acquire stuff, you just put it in there as you go, and, you know, update it and review it and update it on a regular basis. And, you know, I've had a lot of young couples that have done that over the years, and it's worked well for them.
Yeah. Well, I think these concepts of the death box, just getting a will in place, are very tangible things that aren't going to break the bank for anybody.
Yeah.
But then also just the awareness of, hey, we do need to get a trust set up. What's the best step when looking for a great estate planner, Marty? What are some things I should be looking for as I look for an estate planner out there? Obviously, if someone's in Oklahoma, I think you work in a couple other states maybe, but what's the best way to work with you? But then also if they live in Canada,
Yeah.
or maybe that's a bad example because it's a different country. They live in California. What's the best way to approach estate planning
Well,
and finding a good estate planner?
I think in any state, if you have, ask around, ask people you know who have done it in the local community, who, if they've had any experience with the local attorneys. If you have a financial advisor that has helped you kind of set up your initial retirement planning, you might ask them for resources. Have you worked with any estate planning attorneys, and what's been your experience with them? Do your online research. And my best advice is, but you want to find someone who will spend the time to sit down and really get to know and understand you, your family, your kids, and spend the time on your goals. And those people will sometimes show up when you in an initial consult. You may have to, meet with 2 or 3, but as you go around, but you want someone, and then, find someone that has a process to make sure that the plan gets drafted and implemented. And if you're going to go the trust route, that it gets funded properly, and that there's documents in the file to verify that that has happened, that you can prove it 10, 20, 30 years down the road. And then also consider, is this firm going to be there to help me if I or my spouse become disabled, or if we have a death? I mean, who's going to be there is this firm going to be there to help carry out this plan on the back end and counsel and guide the surviving spouse? That's typically what we call settlement, or trust administration, or settlement. So
if they want to take the next steps with you, what should they do?
Well, I mean, if they wanted to learn more about working with us, the best way is just to reach out and call our law firm, or go to the website and get scheduled with an initial consultation. And then we would have a brief telephone conference to see, is this kind of the would we might potentially be a good fit? And then we would send, we have some electronic digital forms to start gathering more detailed personal information and data and family questions, and start identifying some potential goals, and also gathering some asset information. So it's kind of a discovery process of gathering some information, and then sitting down to have in our process to have what's called a get acquainted meeting. We're going to sit down, and we're just going to learn about each other's story, and spend a lot of time listening. I think in my experience, there's a lot of times that lawyers don't listen very well, unfortunately. And so I think what I've learned in estate planning is the better listener you are, the better you'll be able to counsel and guide your client to what tools they need to use: wills, trust, powers of attorney, healthcare documents. Then you can guide them to create what I call as a plan that's actually going to work. It's not based on the documents, it's based upon the results of the planning. So,
And can we get your actual number and email and website?
Yeah, it's 405-364-2246. And for new inquiries, or to learn more about how to set up an initial telephone conference and then maybe proceed, you'd want to email Cynthia at estateplanersforlife.com. Cynthia at estateplanersforlife.com. She's kind of our client services intake coordinator that will get you scheduled for an initial telephone consult, not potentially, with an attorney, and then we kind of go from there, start gathering some data and information.
Okay, fantastic. Marty, it's been fantastic having you on. Thank you for sharing so much. We'll put links to your website, but also to Cynthia and to your phone number down in the show notes if anybody's interested. And thank you for helping educate us on estate planning.
Well, I had fun. Thanks for asking me to do this.
Yeah, good.
It was very enjoyable, and you guys are doing great work. And I went back to look at some of your prior ones with you got a great following and a very successful. You help take care of a lot of people. So I'm honored to be on your program. Thank you.
Okay.
Well, thank you. Okay.
Thanks, Marty.
Take care.
See you.
You made it to the end of the episode, but before you go, if you found yourself thinking about growing your construction business while listening today, I want to share something with you. It's called our 24 Things to Hiring and Training the Perfect Executive Assistant for Your Construction Business. And it's a free guide that we've created. It's not theory, it's what we actually use to help contractors hire the perfect executive assistant. And really, we help you find ways to delegate over 50% of your current workload and get back 20 hours of your time every single week. You didn't start your construction business to just be doing admin work, to be buried in paperwork and endless admin tasks. This is the guide that shows you exactly how to find and train someone who can actually take all that weight off of your shoulders. So this is a real actionable, great PDF that has templates and processes. It's really, really great. And I want you to check it out, even just to get your feedback and how we can make it even more valuable. But I know that you're gonna love it. The link is in the show notes. Please download it. We'd love to see how much of an impact it makes on you and your business. Thanks for listening to the full episode. Check out the guide. It's free. No reason to hesitate. No reason to wait. Download it now. And before you go, I just want to ask for your gracious subscription to our podcast. So if you have 2 seconds, it means the world to us. Just subscribe on YouTube, Spotify, Apple, or if you'd like our weekly newsletter delivered to your inbox whenever we release an episode, please subscribe in the show notes. Every week, we're talking about real strategies on how you can grow and build a profitable construction business that runs without you, so you can have less stress, more time, and more money. Click subscribe wherever you listen to the show, and thank you again for checking out the Cashflow Contractor. See you on the next episode.